Today, we're diving into a legal fight over a single home that ended up asking some really big questions about our entire justice system. This isn't just a story about a foreclosure. It's about the procedural traps and, the massive power imbalances that can decide who wins and who loses in court. All right, let's get into it.
So what's this all about? Well, it boils down to this number, $305,000. That's the amount of home equity that one man, Jeremy Boss, was trying to protect. And that's the stake that fueled a multi-year war against two corporations. And that really brings us to the core question of this whole thing. How does one person, representing himself by the way, manage to take on what's essentially a corporate foreclosure machine? And in doing so, expose these deep fundamental questions about what it even means to get a fair shot in court. We're going to follow the paper trail to find out. All right, so let's set the stage for this showdown. It's pretty straightforward. On one side, you've got the homeowner, and on the other, you have the two corporate entities that bought his home at a foreclosure auction. And you can see right here, we've got two completely different stories. You have Jeremy Bass, who's acting as his own lawyer, and he's not just making small claims, he's alleging serious stuff, auction rigging, fraud. But the corporations, DPW Enterprises and Mountain Prime, they're framing it completely differently. To them, this is just a simple, straightforward property transfer. Hey, we bought the house, now we want him out. Now the whole battle comes to a head on this one specific legal battleground, summary judgment. You can think of it as a legal shortcut. It's a way for a judge to end a case early without a full-blown trial. If one side can convince the judge that there are no significant facts in dispute, they can win right then and there. It's a super common tactic in foreclosure cases, and it's exactly where the corporations decided to make their move.
So the corporations, they had a playbook. They built an argument that was designed to be really simple, really powerful, and frankly, almost impossible to argue with. And it was all based on specific legal protections written right into Idaho state law.
Their argument was, well, it was a pretty clean four-step logic. 1. We were the highest bidder. 2. We got the official deed. 3. Idaho law gives special protection to buyers who purchase a property in good faith. And 4, because of all that, we win. Game over. You can see it's a very calculated way to make this whole messy situation seem like an open and shut case. And everything hangs on this legal term, good faith purchaser. Now, this isn't just some casual phrase. It's a really powerful legal status. It means you bought a property for a fair price without knowing about any funny business with the title or the sale itself. And if a court says you qualify, the law basically puts up a shield around you, protecting you from future challenges. The corporation's entire case was built on claiming they had this status. But Jeremy Bass wasn't having it. He went right after that core idea. His entire defense was a direct attack on their claim of being these innocent, good faith buyers. And man, he came back with some serious allegations. He claimed the plaintiffs didn't just show up and happen to win. He said they actually coordinated with the trustee beforehand. He argued they absolutely knew there were problems with the property title, that he was even intimidated by their representative before the sale, and, this is a big one, that the entire foreclosure was legally bogus from the very start. Every single one of these points is a direct shot at their good faith claim.
Okay, so this is where the story really shifts. It stops being about the facts of the auction for a minute and becomes all about the legal process itself. A frantic race against the clock that put a self-represented guy like Bass at a huge disadvantage.
Just look at how this plays out. The plaintiffs filed their motion. A month later, Bass files his response. But then, just 3 business days before the hearing, on a Friday no less, the plaintiffs file a reply that drops new evidence into the case. So Bass has to scramble all weekend and files 3 separate responses on Monday, the day before the hearing. Talk about a pressure cooker.
And then, bam! At the hearing, the judge delivers what is basically a knockout blow. Citing the rules of court procedure, the judge just flat out refuses to even look at the 3 documents Bass filed. So, on a technicality, his final, most critical arguments were thrown out before they were even heard.
So you have to be asking, right? What was in those documents the judge refused to see? This is where we get to the evidence the court never even considered, the potential smoking guns that were left sitting in the hallway outside the courtroom.
First off, Bass accused them of playing a shell game with the word notice. See, he argued they were intentionally confusing 3 very different legal ideas: the public notice of the sale, the notice to vacate they sent him after, and the most important one, their notice of issues with the sale beforehand. because if Bass could prove they had that kind of notice, it would completely destroy their good faith purchaser claim.
But that wasn't even the biggest thing. The most explosive piece of evidence, well, it came from the plaintiffs themselves. Buried in that last-minute document they filed was a straight-up admission.
Right here, in their own sworn statement, they admit it. They contacted the trustee before the auction to get non-public information, the lender's exact opening bid. Now, Bass argued this wasn't just innocent homework. This was evidence of collusion. This was the kind of coordination that absolutely demolishes any claim to being an innocent, good faith buyer.
And this is where it gets really clever. Bass took the legal precedent they were using to defend themselves, a case called Breckenridge, and he turned it right back on them. Look at this. In Breckenridge, there was zero pre-auction contact. Here, they admitted to it. In Breckenridge, bidders brought checks for way more than the bid, expecting a competitive, unpredictable auction. But here, the plaintiffs allegedly had a check printed for the exact final bid amount down to the penny. It strongly suggests they knew the outcome way in advance. And just like that, with that one procedural ruling, this whole thing blew up. It wasn't just about a single house in Idaho anymore. It became a challenge to the fairness of the entire system, a fight that was now aimed squarely at the Idaho Supreme Court.
Let's be super clear about what this means. Because the judge threw out Bass's final filings, the court never had to officially weigh the plaintiff's admission about contacting the trustee. It never got to consider what it means to show up with a pre-printed check for the exact winning bid. The most powerful evidence suggesting this whole auction might have been rigged was never even officially part of the case.
And this all leads to the huge, profound question that Jeremy Bass ultimately took to the Idaho Supreme Court. In plain English, he's asking this. When we say that regular people representing themselves have to follow the exact same complicated rules as high-powered law firms, are we also pretending they have the same legal knowledge, the same resources, and the same ability to respond to last-second legal attacks, or does real justice demand something more? It's a question that cuts right to the heart of what equal access to the law really means, and it's a question that, for now, remains unanswered.